Hello students, UPSC is not testing how much you have studied. It is testing how deeply you understand the constitution. And most students make one mistake, that they try to memorize Indian polity. But UPSC does not reward memory. It rewards understanding through judgments. In the next few minutes, if you watch this till the end, you will not just understand polity. You will start solving questions with confidence. So make sure you stay till the end. And if you think it helps you even a little, do like the video, share with your fellow aspirants, and subscribe for more such UPSC focused content. Today, we are not just reading a book of rules, but listening to amazing stories. My name is Shankar Rai, the founder of Rayacademy. Today, we are going to take these sessions. Our constitution is like a great hero, and over the years, the Supreme Court has helped it fight for the justice. Each court decision is a thrilling chapter. Let us see how the court protects every single one of us. Without any delay, let us begin. So, today's video is all about Indian Constitution through judgments. And today I am going to teach you the important cases, the Supreme Court judgments, which are very important for your UPSC prelim examinations. And the judgments are from 1950 till this year 2026. Stay tuned. Students, if you look at the previous year question paper, the judgments plays a very crucial role if you think about the prelims exam. For example, let's say there is a case called as IR Kohilio case 2007. There was a question asked in 2018 UPSC prelims. Consider the following statements regarding the 9th schedule of the Indian Constitution. So the Parliament of India can place a particular law in the 9th schedule. The validity of a law placed in the 9th schedule cannot be examined by the court. So this question can be answered only if you understand the IR Kohilio case. Similarly, if you look at another question paper which is related to Puttu Swami judgment and right to privacy. So right to privacy is protected as an intrinsic fundamental right under Article 21, right to life and personal liberty. And this has been given as a judgment in the Puttu Swami case. So there was a question. In 2018, which part of the constitution appropriately implies, okay, right to privacy, which part of the constitution appropriately implies? Article 21, freedom in part 3 of the Indian Constitution. If you look at another question, for example 2020, there was a question on basic structure doctrine of the Indian Constitution. Question was, consider the following statements. The Constitution of India defines its basic structure in terms of federalism, secularism, fundamental rights and democracy. The Constitution of India provides for judicial review to safeguard the citizens and liberties, to preserve the ideals on which the Constitution is based. So this particular, if you understand the Kesavananda Bharati case, then probably you will be able to answer this question in a more appropriate and in a more correct way. Another question, procedure established by law to due process shift. We have seen it in Maneka Gandhi case 1978. So there was a question in 2023 prelims examinations. Due process of law means what? There were 4 options. The principle of natural justice, the procedure established by the law, fair application of law, and equality before the law. So if you, and there are many more questions which are either directly coming from one particular judgment, or there are certain questions where the judgment per se is not mentioned, but if you don't understand the judgment, you may not be able to answer in an appropriate way. So today we are going to understand this in a very comprehensive way. So if you try and understand the, I would say, the judgments, यहाँ पे 2 approaches है. there are two approaches. How can you understand the judgments? Number one, you can understand the judgments through chronological approach. What do you mean by chronological approach? Since 1950, let's say till this year, till 2026, in a sequence way, in a timeline manner, in a chronological way, you can understand these judgments. So if you follow this particular approach, what are the benefits? First of all, you will start understanding and feeling the reflection how the constitution is interpreted throughout the time period. Second thing, it will help you understand the ideas developed over the period of time. It will also show you how the judicial thinking from a more liberal, then conservative, then balanced view. It will also show you the Supreme Court of India's power, or the India's judiciary power versus the Government of India, versus the Parliament. Similarly, it will also give you the context of historical and political context, because every judgment is a time that it reflects. So it is very useful for building a strong conceptual clarity. So this is one approach. There is also another approach which is called as theme-based approach. Means you pick up a theme. For example, let's say fundamental rights. What are all judgments related to fundamental rights? This you can understand. For example, there is a judicial review. What are the judgments related to the judicial review? So this will also help you for the quick revision purpose. What I am going to do, I'll give you a summary of theme-based approaches. Okay, I'll give you a brief of theme-based approaches, and also I'll give you the in detail chronological approaches. Sit back, and I request all of you, you can pick up a pen and paper, note it down, because I'm going to discuss more than 50 judgments which are highly important for the upcoming UPSC Prelims exam, and even if it is also important for the upcoming mains examinations. This is equally important if somebody is preparing for the state PCS exams. Students, first let us try and understand the chronological evolution of the judicial judgments. Okay, so I have divided into a couple of phases. First phase I have given as phase 1, that is 1950s, the beginning of the Indian judiciary, that I call it a foundation phase. So when you understand the phase 1, there are a couple of judgments. For example, Romesh Thapar judgment. You understand freedom of speech, Champakam judgment, equality versus reservations. Don't worry, I'll explain each and every judgment in more detail, in a more comprehensive way. So this video is going to be a little longer because there are more than 50 judgments which we will understand. Okay, so this is a summary. First of all, I'm just trying to give you a glimpse what all I'm going to cover in this particular video. Second, देखो थर्ड जजमेंट आप लोग ये थोड़ा सा देख लो. Sankari Prasad, amendment of the fundamental rights and zero to religious freedom, it is defined. This is phase 1. If you go to phase 2, then you will find a bit of emerging conflicts. For example, in wherever union case, the amendment needed for the territory. Okay, in the Kharak Singh case, the privacy concept will come. In the Kedarnath case, the limitation to the free speech will come, and in the Golaknath case, fundamental rights cannot be amended. That was the judgment given by the Supreme Court. Similarly, if I come to the phase number 3, 1970s, there were certain constitutional crises. All of you know that this is the phase where a lot of turbulence has gone. 1962, just after 1962, there was a Indo-China war. 1965, there was a conflict with the Pakistan. 1975, there was emergency. Okay, so that is the reason why you can find out the judgments accordingly. Constitutional crisis. So there is a Cooper case, RC Cooper case, expansion of the rights. Kesavananda Bharati case, one of the drastically landmark judgment regarding the establishment of the basic structure. There is also another case, ADM Jabalpur case, that's the emergency, and Maneka Gandhi case, due process and the liberty. If you go to the phase number 4, that is 1980s onwards, so the rights expansion era means more liberty, more rights has been granted to the citizens, and it is in a continuous process. In a mineral case, there is a view of balanced fundamental right versus DPSP. Okay. In Olga Teli case, right to livelihood is established. In the Sahabanu case, secular versus personal law, the conflict came in picture. In MC Mehta case, you will find out the judgments related to environmental rights. Alright. So these are the 4 phases, and after that I have also divided into another 4 phases. Phase number 5, 1990s, there is also a little bit of democratic stability. You can find out from the judgment related to the democratic stability. For example, Kyoto Holohan anti-defection law. Then Indra Swani case, reservation framework 1992 case, all of you know that in Indra Swani what has happened, that a maximum reservation that can be granted is up to 50%. Up to 50%. Similarly, there is a Mohini Jain case, right to education, and there is a Bisaka judgment regarding the workplace dignity, and later culminating into the POSCO Act. So phase number 7, 2010 onwards, you can find rights revolutions. For example, Puttaswamy judgment, right to privacy, then Naptes Johar case, LGBTQ rights, then Joseph Sain adultery decriminalization, and Shreya Singhal case regarding the internet freedom of speech. Okay. After, I would say, now in the 2000s also accountability phases, for example, Iyer Kohilio 9th schedule, Kuldeep Nair, Prakash Singh police reforms. So after 2020s, modern constitutional interpretation has started. Anuradha Vaishyan internet rights, EWS case, Anup Barwal case, and Supriyo case, this has come into the picture. So I'm just giving you the summary. Do not worry. I'm going to teach you. I'm going to tell you the each and every details of each case in one slide. So students, if you look at the more contemporary shifts of the judgments, phase 9 2024 25 recent phases, if you see, there are a couple of cases related to the electoral bonds, climate justice, governor case, and custodial right cases. So if you take a final track away the constitutional evolution, in the very beginning of the phases 1950s, so state power dominated. In 1970s, there is a conflict between parliamentary versus judiciary. In 1980s to 2000, you can see the rights expansions. In 2010, individual dignity and identity, and in 2020s, there are more cases which are in regards to the technology, transparency, and climate. So students, if you look at the trajectory of the Indian Constitution, it is reflecting the journey from governance to the rights to dignity to the future challenges. So it gives us a very clear clue that how the Supreme Court and the Indian judiciary has navigated through the societal changes and the need of the hour. So similarly, if I talk about the theme-based approach, theme-based means if I pick up a theme, particularly fundamental rights and liberty, you can find out there are many cases. For example, A.K. Gopalan, Romesh Thapar, Karak Singh. I'll give you this PPT in this Telegram group. Okay, you can check the Telegram group in the description. So I'll post the entire PPT there. You can download and you can read it, because these are highly important for your prelims examinations. In case it is asking like which case is known as the habeas corpus, consider the following statements so and so, there will be certain statements. ADM Jabalpur, Maneka Gandhi case, Sunil Bhatra, Hussain Khatun, Olga Teli. So these cases are related to fundamental rights and liberty. Similarly, students, if you look at the contemporary rights and evolutions, for example, Mohini Jain, educational right. Okay, Uni Krishnan, structural education. Shreya Singhal, section 66A, struck down the freedom of expression or freedom of speech in the internet. And Puttaswamy case, 2017, privacy. Anuradha Vaishyan, internet freedom. Vaidyo Devi, property as a right. And S.G. Bompattai, sedition. And Bihan Kumar, dignity in the arrest. Similarly, if I talk about the federalism and separation as a theme, there are certain cases. For example, Beruwari Union case, State of West Bengal versus Union of India 1963 case, R.C. Piyodal versus Union of India, S.R. Bomai case. Similarly, Iyer Kohilio case, T.S.R. Subramaniam, Anup Barwal, and ADR versus Union of India. So these cases are with regards to the federalism and separation of power. Why is it important? Because when you are going to write mains examinations, let's say essay, you can clearly see, okay, these are the cases which are available with me ready-made. I can give certain examples with regards to the case. In prelims exam, it may happen They consider the following statements in regards to federalism and separation. They may give you a statement. They may put a particular case in that statement. Okay. So if you have not gone through these particular statements, then you may find it very difficult to answer the question. Students, if I talk about gender justice and social equality, there are certain cases. What are those cases? For example, Muhammad Ahmed Khan Sahabano case, popularly known as the Sahabano case. Then there is a Visakha judgment. Then there is Sayara Banu versus Union of India, triple talaq judgment, which you call it. Then there is Napte Singh Johar Jodai, what is known as LGBTQ rights. Hadia judgment that is related to choice in the marriage. Similarly, there is also women entry in Sabarimala case, Indian Yawn Lawyers Association versus Kerala. Then there is adultery struck down, Joseph Sain versus Union of India. Independent thought versus Union of India, child marriage exceptions. Karnataka hijab case, uniform upheld, and Supriyo versus Union of India, same-sex marriage case. So these are cases which are related to gender justice and social equality. See, there are n number of cases interpreted by mostly the Supreme Court of India and the High Court. But for the UPSC purpose, civil services purpose, we no need to remember each and every case. I am just giving you the bare minimum what is important for your exam point of view. Alright. Similarly, if we look at the environmental and sustainable development case, okay, that is the theme, then we may find MC Mehta versus Union of India, absolute liability. Then there is Subhas Kumar versus State of Bihar. Then there is Veller Citizens Welfare Forum versus Union of India, poultry pays. Okay. Similarly, you can also find out that regarding climate rights, regarding gene campaign, that is a genetically modified crops, okay, GM crops. So if you look at governance, transparency and accountability as a theme, you can also give these examples in your governance chapter. India Nehru Gandhi versus Raj Naran free and fair election, Minerva Mill case, DC Wardha case, Kyoto Holohan case, anti-defection. Similarly, okay, PUCL versus Union of India voter rights, Lily Thomas case, disqualification of the member of parliaments, and Supreme Court of India versus Subhash Chandra Agarwal, CJI under whether the Chief Justice of India is under Right to Information Act or not. Okay, then there is a Balram Singh versus Union of India, preamble upheld. So students, you can clearly see, if you look at the judicial appointments and independence, there are certain cases, for example, SP Gupta, Senior Advocate on Records as Associations versus Union of India Collegium System. Then the third judgment case, Supreme Court Advocate on Record Association versus Union of India, where NJAC struck down Article 124, okay, Clause 1, it was struck down. So if you look at the judicial procedure and remedies, you can find out Rupa Ashok Hurar versus Ashok Hurar, the evolution of the curative petition. That means if the Supreme Court has given a death penalty to someone, there is a review petition, and after the review petition, beyond the review petition, there is also another stage that is called as curative petition. So curative petition is basically to rectify the if there is any scope of misjustice by the judiciary. So this is the Swapnil Tripathi versus Supreme Court of India live streaming of the judiciary proceedings. Brij Mohan Lal versus Union of India fast track courts. SP Sampath Kumar versus Union of India and tribunal validity. So students, in this particular slides, I have given you enough informations that what I am going to talk about in the detail of my video. So stay tuned. This is going to be a little longer, but I am sure that you will all appreciate my hard work and my effort which I am putting for all of you, so that you can score a better mark if any questions regarding these judgments, and that will come in your UPSC, as well as this will also give you a better understanding for interpretation of the constitution, understanding the Indian polity, and taking the meaning out of it. So stay tuned. Okay, let us start with our first case, that is A.K. Gopalan, 1950. Students, the story of our personal liberty starts right here, but it also begins on a very challenging note. This is about Mr. A.K. Gopalan, who happens to be
a political leader who was detained by the state under a preventive detention law. He asked the Supreme Court of a big question: is the government's procedure for taking away my freedom just, fair, and reasonable? Let us try to understand. So, if you look at the case snapshot, this is how I have tried to give you details. The case snapshot was basically the legality of the detention and early interpretation of the fundamental rights. What was the issue? The issue was, what is the scope of Article 21? The procedure established by law. What are the linkages between Article 14, 19, and 21? As I told you, the question was, is the government procedure for taking away my freedom just, fair, and reasonable? So, Supreme Court has held that procedure means any law that is enacted by the state. In 1950, the court gave a narrow answer. It ruled that procedure established by the law, which is mentioned under Article 21 of the Constitution, means the procedure written down in a law passed by the legislature. The court said it could not check if that law itself was unfair or unreasonable. Now you can clearly see that here the court is denying the due process of law. The due process of law, which we will later study in Maneka Gandhi case. The court also said that it could not check it, initially gave the state very strong power and led to narrow view of personal liberty, that is under Article 21, because Article 21 is right to life and personal liberty. It is important to remember that this case is a starting point. The judgment treated fundamental rights as a separate and isolated boxes. However, this narrow view was later completely overturned by the landmark judgment in 1978, where the due process of the law is established, where not only the articles or the sections of the law will be checked, but also the intention of the law will be checked. Okay, so what is the long term impact? We have already discussed it. The beginning of the evolution of Article 21. Immediate outcome is narrow view of personal liberty, limited judicial scrutiny, and strong state power. But if you look at the long term impact, from procedure established by law, now slowly we are coming into due process of law in Maneka Gandhi case. Now, if we go to the next case, that is Romesh Thapar versus State of Madras, 1950. Now, who is Romesh Thapar? Romesh Thapar, basically a journalist. This is a journalism. He used to publish a editorial magazine. That is, the name of the magazine is Crossroads. What has happened? The story of our freedom of speech begins here. The court established that a free press is absolutely vital for a democratic government to work well. Remember, right to press, later it is established as an intrusive fundamental right under Article 19, Clause 1. So, this was the issue. Madras High Court banned a journal, that is the name of the journal is Crossroad. So, Romesh Thapar challenged it. Okay, the theme is in regards to the press freedom. What is the reason? Why did the government ban the journal? Because they criticize the government policies. What is the justification? Why did the government ban it? Because it is a threat to public order. So, it confirmed that without the freedom of speech, democracy is meaningless because the government cannot be held responsible. So, press freedom, as I told, it is already under Article 19, Clause 1, Subclause A, freedom of speech and expression. Now, court told that public order is not a valid reason during that time. I am talking about the 1950, is not the valid reason based on which you can ban or you can put certain restrictions on a journal. So, why it matters? Because it is the first landmark judgment on the press freedom. It also strengthened free speech protection. It also triggered and gave a way to first Constitutional Amendment Act of 1951. And later, the public order, it is added as a restriction, as a ground for the restriction of to the freedom of speech and expression under Article 19, Clause 2. So, this is the story of Romesh Thapar versus State of Madras. I am also here mentioning the theme so that you better understand which case is related to what particular snapshots. Next case, which is very important, Sankari Prasad versus Union of India, 1951. Now, I want all of you to imagine a tug of war between Parliament and fundamental rights, especially the court and the the government. In the first round, the court ruled that Parliament could amend the fundamental rights. Okay, let us try to understand what is the case. Now, what is the theme? The theme is basically the amendment or amending power of the Parliament up to what so far the court can amend it. What is the context? Sankari Prasad had challenged the first Constitutional Amendment Act. And within that first Constitutional Amendment Act, the right to property, which was earlier present as a fundamental right, there are certain amendments that were made to right to property. So Sankari Prasad filed a case and he held that fundamental rights cannot be amended. Now, what is the question? Requisition. So, requisition is, do Parliament has the authority to amend the fundamental rights under Article 368? Can Parliament amend fundamental rights? What is the scope of amendment versus protections? So, if you look at the Sankari Prasad case, Supreme Court also gave a very wider view that amending power is plenary, means amendment is not law under Article 13 Clause 2. Please try to understand. See, the Article 368 says that power of Parliament to amend the Constitution and the procedure thereof. Means Parliament has the power to amend the Constitution. Okay. So whenever the Parliament tries to amend the Constitution, it is treated as Constitutional Amendment Act. Constitutional Amendment Act. So first of all, they have to present as a constitutional amendment bill. So similarly, if you look at the law, the definition of law is under Article 13. Okay, under Article 13, Article 13 is a basically part 3 under the fundamental rights. So it is mentioned that what is called as law. So Supreme Court has told that the constitutional amendments are not basically laws. Constitutional amendments should be treated as only constitutional amendments, and rest of the things can be treated as a law. Means if the statutory body like Parliament or the state legislature, if they pass a bill, make a law, or maybe the executive order something, that can also be treated as a law. So the Supreme Court has held that yes, the Parliament has two types of power. Remember, I am talking about 1951. Okay, so Supreme Court has held that Parliament has two types of power. One is constituent power, okay, constituent legislative power. Another one is basically you can say is ordinary legislative power. So why it is constituent legislative power? Because during 1951 the constitution is being framed in the Constituent Assembly. So the court has observed that if the Parliament uses ordinary legislature, then the Parliament cannot amend. But if the Parliament uses the constituent legislative power, then the Parliament can amend the entire Constitution, including fundamental rights. So amendments were declared valid. What is the significance? Significance is that it has favored the Parliament, it has strengthened the legislative supremacy, and amendment power placed above the fundamental rights challenge. Now, if you look at the later stage, later it is also challenged in Golaknath case 1967. It has also triggered the debate, and eventually we will come to understand the evolution of the basic structure doctrine. Later stage I will talk about it in the Kesavananda Bharati case. So, because a constitutional amendment is not an ordinary law, so that can easily be challenged. So, this is what we have understood in the interesting case of Sankari Prasad versus Union of India. Next, if you look at the another case, that is Champakam Dorairajan versus State of Madras 1951. Okay, so in this particular case, if you try and understand, first of all, this is a very interesting story of the woman who forced the first constitutional amendment. So the Madras government has issued a communal geo means government order, that means a caste basis. Okay, so seats were reserved on the caste basis. What is the issue? Let us understand. Basically, the theme is reservation and equality. So the Madras government, when they issued certain government order, and the order is in regards to reservation of seat based on the caste. So the legal issue is caste based reservation in education. Now the issue arises Article 15 clause number 1. What does Article 15 clause number 1 says? The prohibition of discrimination. Okay, the prohibition of discrimination means the state shall not discriminate based on religion, race, caste, sex, and place of birth. What is the court decisions? Okay, the court decisions is that the government order is unconstitutional. Reservation only based on the caste cannot be possible. It is not valid. And because it violates the Article 15 clause number 1, if the reservation is done only based on the caste, then it is not valid. It is unconstitutional in nature. So look at the Champakam Dorairajan, she was denied admission. So basically she dragged the entire machinery and put it in the court. Now we are understanding this forced the parliament to amend constitution to legally enable the reservation for backwardness. If we look at, if we look at the constitutional amendment led to the first constitutional amendment 1951. After this judgment, what has happened? Government has inserted another Article 15 clause number 4. In the Article 15 clause number 4, it is stated that yes, the government can make certain affirmative actions to enable special provision for a backward class. So this is what we are understanding. So what is the takeaway? What is the takeaway? Takeaway is equality strictly enforced initially. There is no caste only reservation allowed. Later what has happened? Yes, reservation can be done, but it has to be based on affirmative actions. Okay, so this is what we are trying to understand. Next case is Sirur Muttu case 1954. This is basically essentially religious practices. Now just think about it. How does the court decide what is truly religious? The religion or the religious or religion is very subjective, is very personal. Now how does the court will decide that which practice is religious and which practice is not? Interestingly, what has happened? Madras Act regulating temples, including control over Sirur Muttu or Matta, you can say, challenge the state interference. Okay, so the challenge, what is the challenge? That Madras government was trying to control the Sirur Matta. Now, this case is created the essential religious practices doctrine. This means the court protects only the core beliefs and practices of the religion, allowing the state to regulate non-essential practices to maintain law and order. Means if you say that yes, we have a freedom under Article 26, that is the religious institution, they have a freedom to maintain. However, Supreme Court has made a very clear directions that what is religious versus what is secular. So the Supreme Court has held that state can regulate secular activities which are non-essential in nature, non-essential. Okay, non-essential. But the government cannot interfere in the matter of religion. So for the first time, Supreme Court has introduced the essential religious doctrine practice. Right? Why it mattered? It is matter because the state control protected autonomy for the religious institution. It is a test what is an essential to a religion. What do you mean by essential to a religion? So the core things, the scope of the Article 25, which is related to freedom of personal religion, and Article 26 is in regards to the institution religions. So freedom of religion, and what is up to what extent? Okay, so if we try and understand, the Supreme Court has clearly stated yes, state can regulate certain affairs of the religious institutions subject to it shall not intervene with the essential religious practices of the particular institution. Okay, state can control non essential practices only to maintain law and order. Law and order. So this is the detail of Sirar Matta case 1954. Now students, if we go next, there is another case called as Berubari Union case 1960. Berubari is a place basically. Okay, this is regarding the a small, I would say, place, a piece of Indian territory to Pakistan. To Pakistan. Let us understand. So the issue was there is a Nehru, noon agreement with Pakistan, proposal transfer part of the Berubari. So it has raised doubts on Parliament's power. What is the Parliament's power? That means can Parliament give a part of the territory to a foreign country? This is in regards to territorial sovereignty. That means all of you understand the Constitution part 1 of the Indian Constitution, that is the Union and its territory. So the central issue is, can India secede territory by Article 3? Okay, all of you know Article 3, or need amendment under Article 368. What is the scope of Parliament versus Constitution? Now, what is the consequences? The court has clarified two things. First, that the preamble is not a formal part of the Constitution. Second, the transferring Indian land to another country requires a full constitutional amendment. So, if you look at the consequences, it led to the 9th constitutional amendment in 1960, formalized transfer process legally, and ensured that there is a constitutional procedure. Okay. So, what is the court's opinion? Court has told that yes, secede is possible, but not by simple law. Only Parliament, by passing a simple law in ordinary majority or simple majority, is not possible. So if you want to acquire territory, then it can be done by a simple law. But if you want to give a certain piece of the territory to another country, then you need a constitutional amendment act under Article 368. Okay, so this has happened when there was a India and Bangladesh land swap agreement. India and Bangladesh land swap agreement. So later on when we talked about it, but yeah, you can say that's a preamble. It in the Berubari Union case, it was a view that it is not part of the Constitution. But later stage, when we see especially in the Kesavananda Bharati case, the preamble is very much part of the Constitution. It is duly recognized. Next case is regard to Kharak Singh versus State of Uttar Pradesh 1962. For the first time, the Supreme Court whispered the word called as privacy. So this is the case or the theme in regard to privacy and personal liberty under Article 21, because Article 21 says right to life and personal liberty. So what is the basically background? The background is Kharak Singh, he was a police suspect. Okay, now the issue is that continuously the police used to visit his home and trying to intervene into his private lives. So he was very much frustrated. He approached the court. He said that if I am a suspect, under what authority the power is granted to the police to continuously surveillance? That is not done. So the legal concern, do I have my Article 21 personal liberty? Does surveillance violate the liberty? Let us understand. So the court has struck down a police surveillance rule that allowed officers constantly watch a citizen, ruling that continuously watching violates a person's dignity and personal liberty under Article 21. So it is a direct invasion of the personal property. Police cannot make a continuous surveillance that is not done under Article 21. It is no explicit recognitions of right to privacy. All of you know the right to privacy is not categorically recognized as a fundamental right. Later on, we will see. Later on, there is also a case that right to privacy is being recognized, but it is very much clear that it is coming under Article 21, personal liberty and right to life. So, if you look at the outcome, it is a first judicial step towards the privacy rights. It has also opened the door as a part of interpretation of the Article 21. Okay, so evolution is that if you look at that 1962 Kharak Singh case, then there is 1975 Gobind case, and finally in 2017 Puttaswamy judgment, the privacy or the right to privacy is considered explicitly. The court has stated that it is a what? It is a fundamental right. So from Kharak Singh to 2017 Puttaswamy judgment. We will talk about Puttaswamy judgment in the later stages. Okay. Now, next case is Kedarnath Singh versus State of Bihar. Now, this is a typical case. Define the boundary of your freedom of speech and expression. Freedom of speech and expression. Okay. Especially, the court has upheld the law of sedition, but only if the speech is intended to incite violence or public order. So, this is the typical case in regards to the sedition. There is a section in Indian Penal Code, section 124A IPC, that is in regards to sedition. Sedition means what? Sedition means if you say something, okay, that may basically perceived by the government as a violations, then they may arrest you. Okay, so law seen as a restricting speech. Question on the constitutional validity. What is the core constitutional doubt? The core constitutional doubt is that Article 19, clause number 1, subclause A is being infringed. Means police or the government using section 124 IPC can basically violate Article 19, clause 1, subclause A, which gives a citizen the freedom of speech and expression. If you say there has to be restrictions, up to what extent? Let us understand what is the Supreme Court stand. Supreme Court has held that section 124A is valid, no problem, but not every criticism is sedition. Every criticism is not sedition. If you say it is a sedition, that means it has to also prove the ground as whether the speech or any kind of expression given in stance of incitement to a violence, or whether the speech has an intention to create public disorder. So narrowed interpretation is adopted. What is the immediate outcome? Immediate outcome is the protection against the misuse up to certain extent. There is a clear boundary of the state action. If we look at the conceptual clarity, the free speech does not mean it is absolute. It doesn't mean that whatever you say it will be valid. So there are certain reasonable restrictions under Article 19, clause number 2. For example, public order is one such reasonable restrictions. Okay. What is the long-term importance? If you say in the long-term importance, it is also a balance between liberty, also security. It is also foundation for the modern free speech in the cases, and it is also guiding principle in the sedition database. So if it protected your right to criticize the government vigorously as long as it does not lead to public backdown. So this is the outcome in regards to Kedarnath Singh versus State of Bihar. Next, this is a very interesting Sajjan Singh versus State of Rajasthan. Okay, the court once again gave a note to the parliament confirming the previous view in the Shankari Prasad case. In the Shankari Prasad case, all of you remember that we have talked about the power of the parliament to amend the fundamental right particularly. Okay, in Sajjan Singh case, if you look at the background, the 17th Constitutional Amendment Act is challenged, and 17th Constitutional Amendment Act, it has inserted various land reform laws into the 9th schedule. I consider 9th schedule as a black hole. Why black hole? Because 9th schedule, in our constitution, whatever law is being inserted in the 9th schedule, they are immune from the judicial review. Hold on, we will talk about judicial review, basic structure. I know all of you are smart enough. You may counter argue that no sir, judicial review is basic structure, it cannot be neglected. We will talk about those things in later stages. So the issue is that under what power Article 368 can Parliament amend fundamental rights and validity of the 9 schedule protection? What did the court say? The court said the Parliament powers, yes, the Parliament has the power, fundamental rights can be amended, and similarly, it has not changed the stance which it took in Sankar Prasad case, and there is no limitation on the amending power of the, you can say, Parliament. The just judicial concern is that Justice Hidatullah, he has expressed certain doubts. Justice Mudavallakar questioned why the Parliament must have unlimited power, and there has to be certain limitation, and this was the hint given in the 1965. And as a result, if we see, it was a temporary push to the legislative supremacy, but later stage we have understood that in Golaknath case and eventually in Kesavananda Bharati case, the basic structure doctrine it has started. Now it protected that we have understood. So this set the stage for the big battle to come that we will understand in the later stage. Okay. So students, I hope all of you are understanding. If you have any kind of doubt, please feel free to leave your doubts in the comment section. I'll surely try to encourage all of these doubts, and I'll try to answer those doubts. So there is an interesting case, that is R.C. Cooper versus Union of India. And this case is in regarding the bank nationalization, or popularly known as bank nationalization case. When the government nationalized banks, this case questioned the action. 1969, the bank nationalization ordinance is presented, and major banks, they were taken by the state. This is challenged by a shareholder, name is R.C. Cooper. The claim is violation of the individual right. What are the issues? The issue is conflict with Article 19, Clause 1, Subclause G, which gives every citizen the freedom to trade and practice any profession. It also has conflict with Article 31, that property rights. Can state compulsory acquire banks? Can state or the government has power to do it? The Supreme Court, if you see, the court has ruled that any law restricting a citizen's liberty must be tested against all relevant fundamental rights simultaneously, significantly expanding the power of the judicial review. Focus on the effect of the law, not just a form. Now, for the first time in the R.C. Cooper case, it has introduced the doctrine of direct effect. Okay, the doctrine of direct effect. Now, if you look at the consequences, it has a strong judicial review of economic policies is coming. State action subject to deeper scrutiny. Protection to the individual rights has expanded. Now, earlier view, separate rights, fundamental rights were looked into separately, but slowly, if you look at R.C. Cooper case, if there is any statements in regards to violation of the fundamental right, it has to be looked as an integrated. At later stage, it has also broadened the scope of the fundamental rights. Kesavananda Bharati case 1973, it has given a stance to the Kesavananda Bharati case, and later stage we will understand. Next, very interesting, that is IC Golaknath versus State of Punjab 1967 case. And again, this is regarding amending of the fundamental rights. Remember, whenever there is a fundamental right, first of all, you have to remember the Sankari Prasad case, then Sajjan Singh case. Okay. Similar stances, yes, Parliament has the power to amend the fundamental rights. Then there is a Golaknath case. And later stage, you will study about Kesavananda Bharati case. Okay. So, in amending of the fundamental rights, these cases are extremely important. So, a major constitutional conflicts begin. The court reverts its earlier stand, declaring that the fundamental rights are transcendental and immutable. Means, if you look at the context, what has happened, land reform laws, especially in Punjab and Kerala, it has affected the right to property. the right to property during that time, it was a fundamental right. Those laws were challenged as unconstitutional. Why? Because the conflict, at one point of time we want to reform, we want more development, and for development we want land, but at the same time the land rights, the right to property, it was a fundamental right. So the core legal question once again come into the same arena, that is, can parliament amend the fundamental rights? What is the meaning of the law under article 13 clause 2? What is the scope of the article 368? Okay, so the Supreme Court has held that no, parliament has cannot amend the fundamental rights. Remember, in Shankari Prasad case and Sajjan Singh case, Supreme Court told that parliament has the power to amend it. But in Golaknath case, categorically the court has held, reversed its earlier judgments and held that no, it cannot. Because constitutional amendments are similar to Article 13. And any amendment that is violating fundamental right, that is unconstitutional and void. Okay. So what is the effect? Effect is that the parliament's powers, these are temporarily frozen, fundamental rights given higher protection, and measures shift from earlier ruling. Now, as a response, what Parliament did? Parliament made 24th Constitutional Amendment Act. Parliament once again restored its amending power, and we will understand in later stage that it has gave rise to basic structure doctrine debate. Students, the famous case, that is Kesavananda Bharati versus State of Kerala. I hope you all are appreciating the story way, because I am going in a very chronological so that you understand how there is a more power in 1950s with the parliament, and slowly the court is making a balanced opinion and balanced view and giving more protection to the citizens. Okay, so Kesavananda Bharati versus State of Kerala 1973 case, to be very precise, 24th April 1973 case. Now, this is the most critical judgment in Indian history. The Kesavananda Bharati, challenged by a seer Kesavananda Bharati, because the Kerala land reform laws were questioned. Okay, so the fear is Parliament has unlimited authority to basically amend anything that it wants. What are the constitutional issues? Constitutional issues were, what is the scope of Article 368? Is amendment power unlimited? Can a constitution's identity be changed? The ruling is historic because Supreme Court has held that Parliament can amend the constitution. Remember, why the ruling is historic? Because in Golaknath case, it is categorically stated that the Supreme Court, the Parliament cannot amend the fundamental right. But in Kesavananda Bharati case, okay, it has stated that Parliament can amend the constitution, but it cannot destroy the core features. For the first time, it is a judicial innovation that basic structure doctrine is created. What do you mean by basic structure doctrine? Imagine you live in a house which has pillars. Okay, so upon that there is a house. So if you break down these pillars, what would happen? The entire house will collapse. So similarly, the court has expressed the country to run, there are certain fundamental pillars. For example, secularism, judicial review, democratic form of the government, republic form of the government. Okay, and there are many more. So if you take away these things, then what would happen? Ultimately, the entire country will collapse. So similarly, the preamble is a part of the constitution. Certain part of the 25th amendment were struck down. What is the immediate outcome? Immediate outcome is that it has restricted the power of the parliament. Okay, so judicial review is now more strengthened, and it ruled that the parliament can amend the constitution, including the fundamental rights, subject to the basic structure. Okay, so you can amend, but that doesn't mean that you will destroy everything. Are you understanding? So it has also given a balanced view between flexibility and stability. Now, the long-term impact is that it is a foundation of the Indian constitutional law. It has also ensured that there is a constitutional supremacy, means the constitution is supreme, and the balanced between parliament versus judiciary. The very next case, that is ADM Jabalpur versus Sipkan Shukla, 1976. This case is popularly known as habeas corpus case. All of you know the habeas corpus. Okay. Now, what has happened? Basically, let me tell you. First of all, habeas corpus. Let me give you a brief about it. Habeas corpus is one of the writ that comes under Article 32 of the Supreme Court and Article 226 of the High Court. What does that mean by habeas corpus? Habeas corpus means to have the body. To have the body means, for example, let's say a person is arrested by the police, and for some reason the family and friends of that particular person is not notified, or they are unable to understand, they are unable to recognize whether the person is live or not, because the police is not willing to cooperate and is not willing to show the person to them. So the friends and families or any of the citizen, they can file or writ in the Supreme Court under Article 32 or under Article 226 in the High Court as a habeas corpus. Then what would happen? The court will order the state to basically appear before the court along with the particular person who is arrested. So this is the habeas corpus. Okay. Now the backdrop is that the period of emergency, all of we know that Indira Gandhi time, she was the prime minister 1975 to 77. There was a large scale of preventive detention. Preventive detention means the police will arrest in a pretext that you may indulge or you may do certain activities which will hamper the public order. You haven't done that yet, but there is a apprehension. So the petitions filed against illegal custody. Government has claimed that the right to move court suspended. Okay, the right to move courts are suspended. Why? The government say that now this is a national emergency, and under the national emergency, the you cannot move to the court. You do not enjoy the enforcement of the fundamental right. So the what is the question? The question is it really true that under the emergency Article 21 is suspended? Can court hear habeas corpus petition during the emergency? What is the scope of the right of the suspension? The Supreme Court, if you see the during the emergency, the court has wrongly agreed that the citizen lost the right to life and could not challenge the detention, even the most illegal one. This failure taught us the critical importance of the right to life. Okay, so you can say this is a dark kind of a chapter in the judiciary, where the judiciary has given a very narrow interpretation of Article 21. Okay, here we see that there are more power with the executive, that means government, than with the fundamental right. Now, critically understanding, it is a dark chapter, and then later stage we will see that in Puttuswamy judgment, right to privacy is being given more importance. But in ADM Jabalpur case, what we see that yes, under the national emergency, Article 21, it is being suspended. The enforceability is suspended. This was the case in habeas corpus. All right. Now, next very famous case, Maneka Gandhi versus Union of India. Now, here is the story of Maneka Gandhi. The government took her the passport without giving her a reason or chance to speak. So she said, this is not fair. If you take my passport and you do not give me a chance to speak, this is not fair. The Supreme Court has agreed. Okay, let us understand. The situation is that no prior hearing was given. The challenge was, she had challenged the arbitrary action. All of you know Maneka Gandhi. She happens to be at one point of time was a minister. Okay, what is the core legal issue? The core legal issue was, what is the meaning of procedure established by law? What is the requirement of fairness? Link between Article 14, 19 and 21 means government has power to take away the passport. Yes, that is fine. But the way government has taken the passport is not fair. So government has simply followed the procedure established by law, which is mentioned under Article 21. But the way they have established by the law, that is not correct. So for the first time, Supreme Court has held that procedure must be just, fair and reasonable, which we say as principle of natural justice. Okay, principle of natural justice. So all of you know what is principle of natural justice? That means the law has to be fair, the law has to be reasonable, and the law has to be just. And arbitrariness in the law is not acceptable. And it has also expanded the personal liberty. It has rejected the narrow interpretations. So here we are observing the due process of law. The due process of law. Remember, this procedure established by law, this is your Britain concept, UK concept. Due process of law is an American concept. Okay. Now, again, the relationship between Article 14, right to equality, Article right in 19, that is freedom of speech and expression, and Article 21, right to life and personal liberty, they are golden triangle. You cannot take away one from another, so they have to work together. Now, here we understand the substantive due process. The more different types of rights framework have been put forwarded. For example, right to privacy, right to dignity, right to have a clean environment. It is also a transformative power. Okay, so this is what we understand in Maneka Gandhi versus Union of India 1978. Important outcome is the strong protection against the state, due process of law or due process principle is introduced, fairness is introduced, and the relation between Article 14, right to equality, Article 19, that is freedom of speech and expression, and Article 21, right to life and personal liberty, it has to work in tandem. So this is all about Maneka Gandhi versus Union of India 1978 case. So this is the story of balance. The case is Minerva Mills Limited versus Union of India 1980. As I told that this is a story of balance, Parliament tried to make a law to give itself unlimited power to change the constitution, even the fundamental parts. If you look at the issue, that is, this Minerva Mill case is a challenge to 42nd Constitutional Amendment Act. And all of you know that 42nd Constitutional Amendment Act is 1976. And this was the time period when the emergency 1975 took place. Indira Gandhi was the Prime Minister. She wanted to make a lot of changes, and 42nd Amendment is considered to be a mini constitution. Why? Because this act tried to amend majority part of the constitution. So let us understand what are the core constitutional issues. The issue here, the question is amending power unlimited? Can fundamental rights be overridden by DPSP, Directive Principle of State Policies? What is the scope of basic structure doctrine? So the Supreme Court has struck down certain parts of the 42nd Amendment. The Supreme Court stepped in saying no one can destroy the basic harmony and the balance of our constitution. It has reinstated that the balance between fundamental right and DPSP is a basic structure which cannot be taken away by the Parliament. So the immediate outcome is Parliament's powers are restricted, fundamental rights are restored importance. If we look at the conceptual insight, the fundamental right with DPSP is complementary with each other. The constitution is nothing but balance between different types of parts. So this is the typical case of harmony and balance. If we look at the long-term impact, the basic structure has strengthened, imbalance prevention is being done, and there is also legal landmark, the defining case for maintaining the delicate harmony of the constitution. In this, the next case is S.P. Gupta versus Union of India 1981. Imagine a debate over who chooses the reference for a match, the players or the team owner. This case was about who appoints judges. The issue is the public interest litigation filed, PIL filed on judges' appointment and transfer. The concern was the executive is interfering in the appointment process. The key constitutional, the questions were, does appointment affect judicial independence? What is the role of executive versus judiciary in context of appointment of the judges? What is the meaning of consultation with Chief Justice of India? This In this case, the Supreme Court said that while the Chief Justice must be consulted, the government still had the primary role in appointments. This is the beginning of a big long debate about judicial independence. The Supreme Court held that executive is given primacy. But CGI's opinion is not binding, so no judicial supremacy is established. What is the immediate outcome? As we come to know, the executive got more power. There is no balance, however, it is tilted towards the government. The consultation is not concurrent. So, the judicial independence with regards to the appointment at later stage, we will come to understand. Uh, this SP Gupta versus Union of India, this case is also known as the first judge case. This is the first time historically recognized as a legal scholarship. In 1993, we will understand second judge's case, it is being overturned, and there is the evolution of the collegium system. Till today, the collegium system is being continued as far as the appointment of judges to Supreme Court and High Courts are concerned. Next, very interesting case is Olga Telis versus Bombay Municipal Corporation, 1985. This is a story of apartment dwellers in Mumbai who faced evictions. They argued, if you take away our place to live and earn, you take away our life. So that means somehow you got the hint that this case is in regards to right to life under Article 21. So there was no proper rehabilitation plan. It was a threat to the survival. So the core legal issue is the scope of Article 21. Does right to life include livelihood? Because if you take away, if you throw away from our place where we reside, how can we survive? How can we have a better life? So the Supreme Court agreed that declaring right to life is not just about physical existence but also includes right to livelihood. So, students, right to livelihood is a fundamental right under Olga Teli versus Bombay Municipal Corporation's 1985 judgment under Article 21. So, because the life without means to survive lacks dignity. Now, conceptual insight, if we understand, life is not merely existence, it also includes survival. So, this is the scope, the Article 21 scope is expanded further. If we look at the transition of the right to life from mere existence to a dignified survival with a livelihood, so it has now become a socio-economical jurisprudence. If we look at the long-term impact, this led to housing and rehabilitation policies for urban poor. Urban governance had changed and also remains a fundamental case for social and economical rights in India as far as the welfare jurisprudence is concerned. Students, very interesting case, Muhammad Ahmed Khan versus Sahabano Begum, 1985. I think there was also a Bollywood movie based on, I think, Haq Hai probably, uh, based on this particular case. So Sahabano, a divorced woman, sought financial support, and her husband argued that his personal law did not require him to pay. So let us understand, Sahabano claimed maintenance under section 125 CRPC. Husband denied. Why? Because it is the Sharia law does not uh, give the protection of financial, even if after the divorce, especially in Muslim personal law, what happens? There is a triple talak, 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 and the divorce is done. So this is a typical question. What is the applicability of section 125 CRPC to all the religion? Is it applied to all the religion or is it applied to only Hindu Religion Act? Does secular law override personal law? What is the question on equality versus justice? So the Supreme Court of India has looked into this particular issue. The court ruled that General Welfare Law section 125 CRPC applies to everyone regardless of religion to ensure basic support and dignity. Personal law cannot deny basic support, and the court also has suggested that there should be uniform civil code, which is also suggested under Article 44 of DPSP. So if we look at the conceptual understanding, the welfare laws are always superior to the personal law. If the welfare law is focusing on social justice and dignity, then it must be offended. So aftermath, if we see, then there is also Muslim Women Protection of Rights of Divorce Act 1986. There were certain political controversies, and there is also Uniform Civil Code debate that is going on. There are certain like Uttarakhand, other states, they have passed a bill in their own legislative assembly in regards to Uniform Civil Code. Next judgment or the case is MC Mehta versus Union of India 1986. This is a story about a gas leak tragedy. The court has realized that dangerous industries must be held to higher standard. Now, oleum gas leak from the industry, it has caused deaths and serious harms. Need for strict accountability. The core legal issue was the scope of Article 21. The liability of the hazardous industries does right to include a clean environment. What does the Supreme Court said? It has instead introduced absolute liability rule, meaning if your dangerous industries causes harm, then you are entirely responsible for the compensation, even if you took every precaution. So this has emphasized that right to clean environment is a fundamental right under Article 21. So conceptual insights, if we see the strict liability, it has become absolute liability. Polluter must be bearing full cost. So first time absolute liability doctrine has taken place. And enforceability significantly higher safety and compliance standard for risky industries. So the outcome is the right to clean environment is a fundamental right under Article 21. Next case, Dr. D.C. Wadhwa and others versus State of Bihar. The State of Bihar repeatedly used a temporary ordinance and emergency law instead of passing a real law through the legislature. Now, all of you know that when an ordinance is nothing but as having a same effect as of law, but an ordinance is promulgated in the state by the governor and in the union by the president. And it is promulgated why? Because there is a need to pass a law if there is a need and there is certain emergencies. So this power is given to the governor for the state and the president for the union, so is to tackle any unpleasant situation if there is a need to pass a law, with a condition that the parliament in the union as well as the state legislative assemblies, they are not in session. Why? Because if the parliament and the state legislative assemblies are in the session, so to make law you have to follow the procedure. The procedure is that you have to, if it is a simple law, then a simple majority is required. It has to be signed by the governor. If there is any consideration, it will go to the president, or else finally the bill will become act. But if the sessions, for example, in India, in parliament we have 3 sessions, in majority of the states also we have 3 sessions. So what if there is a need in between the sessions? So they have a power of ordinance. But in Bihar, what has happened? The government has misused the power of the ordinance. So they used to promulgate the ordinance. Then just before the starting of the session, they used to withdraw that. And again, once the sessions are completed, again they have to reintroduce those ordinance. So it is a systematic bypass of the, I would say, systematic bypass of the power. So the ordinance comes under Article 123 by the President and 213 by the Governor. Okay, what is the Supreme Court's ruling? Supreme Court has held that this cannot be possible. The court has said that this practice was unconstitutional, reminding the government that an ordinance is only for emergencies, cannot be used to bypass the democratic law-making body. So here what we are understanding, it is curbing the executive's power to bypass the democratic law-making process through ordinance. Next is the interesting case, the Quijotto-Holohan case. Quijotto-Holohan versus Jaichulu 1992. This is about the anti-defection law. Anti-defection law. So made to stop politicians from switching parties for power or money. What has happened? The 52nd Amendment Act 1985 introduced the 10th schedule of the Constitution. The aim was to curb political defection, concern over misuse and fairness. So the core question was, what is the validity under Article 102 and 191? Basically, this anti-defection. Does it violate the basic structure? The anti-defection, to defect a person, defect an MP or the MLA, is the speaker's power is final or not? The Supreme Court has held that yes, the 10th schedule is valid, and the speaker's decision is not final. It can be subject to judicial review. So here is an interesting case, the Quixote Holohan case, that we understand that it has ensured democratic stability while preserving the fundamental right to judicial review. That even if the speaker's decision has taken a decision, the aggrieved person can still approach to the court to seek justice. It has also strengthened the overall parliamentary democracy framework in India. Very important case, Indra Savani versus Union of India 1992. This is about a famous case of the Mandal Commission. Mandal Commission case on reservation for OBC other backward classes. So the Mandal Commission has implemented 27 percentages of OBCs in jobs. This policy is challenged in the Supreme Court. The question is, what is the scope of Article 16 clause number 4? Article 16 is basically equal opportunity in public employments. What is the validity of the caste-based reservation? Does it violate the principle of equality principle in the job? Can you make certain reservation in jobs as far as the equality is concerned? So Supreme Court has observed that yes, the OBC reservation is valid because they are backward class, and there needs to be affirmative sections where people can be getting certain benefits from the government through the reservation, and they can come at par with the unreserved category of the people. However, Supreme Court made certain changes. Supreme Court has introduced a creamy layer concept. Also, it has told there is a fixed 50% cap on the reservation. It means if or any state government or the union government wants to give reservation in job, the total reservation cannot exceed 50%. Let me make it simple. Let's say there are 100 vacancies. Okay, then the maximum reservation can be is 50. It cannot be more than 50. Within that 50% of the reservation, you have SC, ST, OBCs and etc. But it cannot be more than 50%. Okay. At the same time, creamy layer concept is also introduced. So creamy layer concept is basically a division. Creamy and non-creamy layer people is a division between within the other backward classes. Also, there are certain community which are upward and which are also downward. So this is the division that has given to the existence or emergence of the creamy layer and non-creamy layer. So the creamy layer concept excluding already advanced section from the reservation benefits to ensure the policy reaches to those who truly need it. So here we are understanding it has forced scientific data collection for identifying backwardness across the state. Recently also you might be understanding that there is a debate going on related to the caste census. There is also normal general census, but there is also a demand for caste census. Next is Mohini Jain versus State of Karnataka 1992. Capitation fees. Capitation fees means admission fee. Admission fee in private colleges were stopping students from getting an education. So if the admission fee is too high, definitely the education cannot be accessed. So the core constitutional issue is in Article 21, it has held right to education, right to free education up to the age of 14 years, 6 to 14. So if the admission fee is too high, how can a person seek seat in the private college or maybe private schools, private educational institutions? Does it not violate the Article 21 right to life and Article 21A? So, what is the state's role in this provision? The Supreme Court has held that the court said education is essential for life of dignity, making it implicit a part of the Article 21 right to life and personal liberty. So, no commercialization of the educations can be possible. Capitation fees unconstitutional, and that has long-term emergence. The Article 21A provided the fundamental basis for right to education. And even there is also Right to Education Act 2009. Okay, remember this is 1992 case, and Right to Education Act came in 2009, directly influencing the legislative framework that made elementary education free and compulsory. So this is education as a fundamental right. Next is the case of Sarala Mudgal versus Union of India. This is the origin of Uniform Civil Code. In the Sarala Mudgal versus Union of India, the personal marriage law, in this case, man tried to convert to another religion only to take second wife without divorcing the first. The Hindu man converted to Islam. The Hindu man did not divorce the first wife but converted to Islam, because in Islam it is allowed to have multiple wives. What is the core constitutional issue? The validity of religious conversion. The link with Article 44 Uniform Civil Code, and also concern related to gender justice. The court has declared that this practice of fraud on the law and invalid. It also urged that government to fulfill every basic necessities that is required. So, the court urged there is a need for uniform civil code, and the conversion from second marriage is not valid. It is a violation and fraudulent on the law. So law cannot be bypassed by the religion, equality over personal loopholes, and there is also gender justice emphasis. Advocating for a common legal framework to ensure justice for all the citizens on the personal law. So the uniform long-term debate is uniform civil code. Now it's going on. Anti-bigamy, reinforcing the legal prohibition of the bigamy across diverse personal context. And also there are reforms that are needed. Next question is Vineet Narayan versus Union of India 1997. When a major corruption scandal investigation stalled due to alleged political interference, the Supreme Court stepped in. So there was a PIL on Jain Hawala scandal. Allegation is that there is a delay in the investigation. There is inaction by agencies like CBI. Concern is that huge political interference due to which the investigation is getting delayed. So the core question is, does it violate the rule of law if the delay is happening? Is it impacting the accountability in the governance? Can executive control any terms of investigations? So here what happened, the issue, it is issued binding guidelines to ensure that the investigative agencies like CBI remain independent and are not controlled by the executive, strengthening accountability in governance. So Supreme Court for the first time 1997 has held that CBI is an independent agency and the executive cannot interfere unnecessarily. So this has upheld the integrity in the governance. So rule of law is always above any political power. If we look at the long-term impact, the agency's credibility has increased. Judiciary will always be available for the vigilance purpose, and the system has gained strength. Next case is Bisaka versus State of Rajasthan 1997. This is what we also say Bisaka judgment. So there was no specific law protecting women from sexual harassment at work during that time. Okay. So the case highlighted violence against a working woman, legal vacuum in the protection mechanisms. The question was, does it not violate Article 14, 19 and 21? What is the right to equality, freedom and dignity? How can the working environment be safe? That is also linked to fundamental right. So Supreme Court has held that using its power laid down the famous Bisaka guidelines, where making it mandatory for all the workplaces to have a complaint committee. The landmark ruling ensured gender justice, right to safe working environment until Parliament passed a formal law in 2013, that is the Sexual Harassment of Women at Workplaces Act, POSH Act 2013. So this is very important that dignity, women dignity is also a core part of the Article 21. It is to ensure securing the fundamental right to a safe working environment through landmark judicial guidelines, that is Visakha guidelines. Next is Kuldeep Nair versus Union of India 2006. This case clarified the scope of Right to Information (RTI) Act. Here, what has happened? The Section 8, Clause 1, Subclause J is challenged. The provision is allowed non-disclosure. Conflict, transparency versus privileges means under this RTI Act there are certain things which cannot be disclosed. So what used to happen, even a basic question is being asked, the government used to say it is non-disclosure. So the core constitutional issue is that what is the use of RTI if majority of the questions are not disclosed, if you are not interested to disclose or if you are not interested to provide. So the question rises in the scope of Article 19 Clause number A, right to speech and expression. How? Because I can only freely speak and write only if I have sufficient information, and it is my right to get the sufficient information using the RTI tool. So it is a privileges versus transparency. The Supreme Court has held that the court confirmed that yes, right to know is an essential part of the fundamental right to free speech. While there has to be certain restrictions on disclosures are necessary, for example, so far as the national security is concerned, our overall goal must be transparency and governance, making public accountability that priority. So the RTI framework has been challenged, public accountability is ensured, there has to be an openness and balance, right to know became a part of free speech, transparency is key to democracy, privileges exist but it is not unlimited. So it has strengthened the democratic accountability by balancing legislative secrecy with public's right to know. Next is Prakash Singh versus Union of India 2006 case. The concern about the politicization of the police forces. The court issued major directions for police reforms. Police reforms. The PIL by the retired IPS officer Prakash Singh issued that there is politicization and misuse of the police because of the certain corrupt politicians. So there is a lack of reform across the state and there is a need for independent policing. What is the core question? Core question is, can state delay or ignore police reforms? Need for standardized structures and link with rule of law. Here what has happened? The court has ordered the creation of independent bodies like State Security Commission and police establishment boards to ensure that the police act as an instrument of law, not politics, thereby boosting the public interest. Okay, so the police instrument of law, not politics, and this has also gained a systematic disclosure. There are structural changes and greater focus on human rights and transparency. It has also secured the operational independence of the police force to afford the rule of law and democratic accountability. Students, if we look at the next case, that is IR Coelho versus State of Tamil Nadu 2007. Very interesting case regarding 9th schedule. Already we have discussed about the 9th schedule in my previous judgments. 9th schedule was created to bypass the judicial review process. The parliament has created the 9th schedule, and if you look at the 9th schedule, there are so many land related laws. During the initial phases, what has happened, 1950s and time period, the land reforms or the land acquiring process is required for the developmentals. And since it was the right to have a property was a fundamental right, it was getting very difficult for the government to acquire the lands. So one of this reason that has made the government to think and parliament passed the 9th schedule and inserted in the constitution, held that judicial, whatever law is inserted in the 9th schedule cannot be, the judiciary cannot intervene into it, the judiciary cannot look into it, the government tried to put laws in the ninth schedule to give them blanket immunity from the judicial review. The court has said that the court, if we see, can the question basically, can ninth schedule laws escape? Remember the basic structure doctrine that has happened in 1973, Kesavananda Bharati case. Now, IR Kohilo case, we are talking about 2007. So, the Supreme Court has held that the laws placed in the ninth schedule after April 1973, they are subject to the judicial review. Why? Because before 1973, there was no basic structure, and judicial review is a basic structure which cannot be taken away by any means. So, whatever laws that are applied in April 1973 onwards, all are subject to the judicial review, even if they are under the ninth schedule. So this has also, you can say, offended the abuse of the prevention. It is a judicial of the balance and constitutional supremacy, ensuring that no law escapes the scrutiny of the constitution through legislative shields. So these are the certain very important judgments. More to come, we will understand. Now we go to the next important case, that is TSR Subramanian versus Union of India 2013. This case is in the context to protect honest civil servants from political pressure. The petition was on the arbitrary transfer of officers. There was frequent political interference, and overall these are impacting the administrative efficacy. The core question was the need for neutral and independent civil services, safeguarding against political pressure, and ensuring continuity in the governance. So the court has observed and mandatorily fixed minimum tenure and established civil services boards. This was done to ensure administrative stability and bureaucratic neutrality, allowing officers to work independently and efficiently. So the long-term impact is reinforced the legal and operational independence of the bureaucracy. This is also directly linked with the contemporary reforms like Mission Karma Yogi. So civil servants as a neutral implementer, because they are the permanent executive, the bureaucratic neutrality is essential. This is also ensuring administrative stability and independence from the political pressure for efficient governance. So this is related to the theme bureaucratic reforms and neutrality. Next case, very important, Lily Thomas versus Union of India 2013. This case targeted the criminalization of the politics, and the theme is in regards to disqualification of the legislators. The context is the section 8 clause 4 of Representation of People Act 1951. There were provisions protected for the convicted MPs and MLAs. Convicted means who happened to done something wrong, and finally the judiciary has convicted them for a jail term or maybe any kind of punishment. But however, the issue was allowing continuation during the appeal, an issue of criminalization in the politics. So this case was trying to prevent entering into the politics for those members who have already been convicted. The core issue is, can convicted legislators continue in office? What is the validity of protection under Representation of People Act? Equality before the law versus special privilege. So the court has ruled that the section 8 clause 4 is unconstitutional, and those who are already convicted, they are immediately disqualified. And that this is applicable if the conviction, the jail term is, or the sentence is more than 2 years. So those who are sentenced less than 2 years, they can continue their political willing and contest the elections. But those who are convicted more than 2 years, so they are barred to enter into politics. So this Lily Thomas case ensured that any sitting member of parliament or state legislature convicted of a crime with a sentence of 2 years or more is immediately disqualified. This ensured that there is clean politics essential for democracy, upholding integrity of the legislature by ensuring accountability and transparency in the public office. If we look at the long term impact, so it has also promoted the fundamental principles of clean and ethical governance. Next is very important, the PUCL judgment, or popularly known as People's Union for Civil Liberties versus Union of India. So, challenging arbitrary phone tapping by the state. The telephone tapping was the issue under Section 5, Clause number 2, Telegraph Act 1885. The concern was the misuse without the safeguard, the fear of arbitrary state surveillance, because by using this Telegraph Act of 1885, which is British colonial legacy, the state or the executive or the police used to tap the telephones of members, which is gross violation of Article 21. That was the question. So, does tapping infringe personal liberty? What is the need for procedural safeguard? Supreme Court has ruled that tapping is not completely banned, but only if necessary and proportionate. It must be backed by the proper procedure. Definitely, privacy is an intrinsic right under Article 21. Immediate outcome is the restrictions on the arbitrary surveillance, and there should be a mandatory procedural safeguard. There should be a procedure when the police or the state tries to tap the telephones of individuals. Privacy is an essential to personal liberty. This case also has established the legal boundaries of the state's surveillance to protect the fundamental right to individual privacy. And the privacy and surveillance is the important theme. So, the Supreme Court has ruled any surveillance must follow a clear procedure and be necessary and proportionate, placing important safeguard against arbitrary state interceptions. And later stage we will understand this has also laid rise to the Puttaswamy case, where the right to privacy made a specifically categorically the fundamental right under Article 21, right to life and personal liberty. Next case, very important, is Nalsa versus Union of India 2014. This landmark judgment recognized transgender identity as a third gender, the protection of the civil rights and equality before the law. Because before that, we have different type of people. We have male, we have female, and there are also people belonging to the third gender or the transgender who do not identify themselves as a male or the female. So the core issue was this gender identity under Article 21 and right to dignity and autonomy and constitutional protection for the safe. So the court has considered that yes, transgenders are third gender, and self-identification of the gender, that whether I am a male or I am a female or I belong to a transgender community, the self-identification is a fundamental right and it is legally binding recognitions. So this has immediately impact in the landmarks, like for example LGBTQ rights, lesbian, gay, bisexual, transgender and queer rights. This has also become the basis for Transgender Act, and gender is psychological and not biological, upholding the fundamental right to self-identify gender and live with dignity as equal citizens. So the court affirmed that the right to self-identification of gender is a fundamental right protected under the Constitution, ensuring dignity and autonomy for transgender persons, paving the way for their social inclusion. So this is the social inclusion, human rights and the legal status are protected. Next is very important, the Shreya Singhal versus Union of India 2015 case. The Section 66A of Information Technology Act, ITE Act. So the arrest has happened of Shreya Singhal because of certain social media post. Okay, so there are certain vague terms which are used by the authority using Section 66A, and there is a concern about the chilling effect on the speech, because when we use the social media and if we criticize the government, does it really violate the fundamental right, freedom of speech and expression protected under Article 19 Clause 1 Subclause A? Should there be reasonable restrictions or excessive control? So clarity was necessary. So finally, the Supreme Court has ruled that the Section 66A IT Act is unconstitutional. It is a vague and there is not it is not a reasonable restriction under Article 19 Clause number 2. So it has also protected the digital expression. If somebody is trying to post certain things on social media, it should not violate the freedom of speech and expression. However, the court also has ruled that there are sufficient sections under Bharatiya Nyaya Sanhita. If somebody is misusing the freedom of speech and expression by means of posting certain, the post which basically destroys the harmony and the public order, or maybe the restrictions under 19 clause 2, then the person can be prosecuted. So here the free speech is protected, and later stage we will understand the digital liberty, internet freedom and speech regulations has been done. So here in the Shreya Singhal case, the court struck down this section, calling it vague and overboard. This ruling was a massive victory for digital liberties, confirming that the freedom of speech applies equally to the online platforms. Next, if we see Justice K.S. Puttaswamy versus Union of India, very important judgment 2017. This is the most critical privacy case. So the challenge to Aadhaar link concerns over the data collection and surveillance, issues of the personal autonomy. Why there is a need to link everything to the Aadhaar? Because Aadhaar also is linked with the mobile number and etc. The biometric and etc. So the core question was: is privacy a fundamental right or not? Does it covers under Article 14, 19 or 21? What is the limits on the state intrusion? Up to what extent the state can get the private data of an individual? So the Supreme Court here has ruled that privacy is very much an intrinsic fundamental right to life and liberty under Article 21. It is classificationally held that yes, right to privacy is a fundamental right, and it is introduced proportionality test. So there is a strong protection of the personal data. State actions must be justified and limited. Individual autonomy is recognized. Privacy means dignity with autonomy. So the state does not have absolute. Rather, if the state wants certain private data, it must explain why it needs it. So this is upholding the individual dignity and autonomy as an intrinsic part of the right to life and liberty. So this has also led the long-term impact to data protection, AI governance and rights landmarks. So Justice K.S. Puttaswamy judgment, the Supreme Court unanimously declared that right to privacy is an intrinsic and fundamental right under the Constitution. It introduced the proportionality test, requiring the government to justify any intrusion into person's privacy as absolutely necessary and proportionate to the legitimate goal. The next important case is Krishna Kumar versus State of Bihar 2017. There is a 7 judges bench, and in regards to re-promulgation of the ordinance, this case clarified that while the freedom of religion, Article 25, is protected, that the government can regulate conversion to ensure they are free and voluntary, not based on force, fraud or inducement. So the challenge to Bihar freedom of religion law, there were restrictions on conversion questions. Concern was, the religion law, whether it is misuse or genuine choice. So the core question was the individual freedom of religion under Article 25 as a fundamental right. Right to propagate versus right to convert. What is the thin line? What is the thin difference? How do you recognize the religion is propagated in a rightful way, or how do you recognize whether the religion is converted in a forceful way? Whether there are restrictions excessive or valid. So Supreme Court has held that the law is constitutional. Conversion must be free and voluntarily. It cannot be forceful, cannot be fraud, cannot be inducement. State can regulate unlawful acts. So freedom is not unrestricted conversion. Choice must be genuine. Individual person must be willing to convert to another religion voluntarily by themselves, not by force. So this is a balancing between fundamental right to practice faith with the state safeguard against the coercion. If we look at the long-term impact, it has led to the social order and voluntariness and regulatory framework. So this Krishna Kumar Singh versus State of Bihar, freedom of religion and conversion, it reinforces the principle of genuine choice. Next important case is Hadia versus Union of India 2018. After a lower court annulled an adult woman's marriage, the Supreme Court stepped in. The adult woman converted religion, married person of her choice. Kerala High Court annulled the marriage and raised issue of personal autonomy. The question was, can courts override an adult's choice? Scope of Article 21, that is liberty, that if I want to convert to another religion and marry, then what is the issue? So freedom of religion and marriage, that was question. So Supreme Court has ruled that marriage restored as valid, adult's choice is supreme, state and judiciary cannot interfere, and right to choose the partner is protected. So the concept, we understand the liberty includes choice of partner, faith and marriage or personal domain. So the right to marry to someone as per your own choice is also a fundamental right. Protecting the fundamental right of an individual to choose their life partner without the said state interference is coming under Article 21 personal liberty. So here it firmly stated that an adult's choice partner regardless of faith is supreme and central to her personal liberty under Article 21. The state or judiciary cannot interfere in a fully autonomous private decision. This has led to individual autonomy, marriage and faith and social control. Next important case is India Young Lawyers Association versus State of Kerala 2018. Challenging the ban on women age of 10 to 50, that is menstruational age group, entering into Sabarimala temple. So the women belonging to 10 to 15 menstruations age barred from entry. These practices followed at Sabarimala temple and justified as a religious custom and challenged based on the equality rights because Sabarimala was a brahmachari. So the core question was, is it not violation of Article 14? If the women of other ages are allowed, why not we? If men are allowed, why not we? It is also violation of Article 15, prohibition of discrimination. It is also violation of Article 21, right to life. Can custom override fundamental rights? What is the scope of religion freedom of versus equality? Remember, Sabarimala case still in 2026 it is going on. Already there was one judgment in 2018, but there is also again renewed judgment and hearings are going on as on 2026. So I'm sure that you will see an evolving outcome in things to come. The Supreme Court has told that no, the ban is unconstitutional because it violates the equality and dignity of women, because if other women are allowed, then why not this certain one section of the people? So the constitutional morality is more than the social customs, and religious practices are subject to the fundamental rights. So what is the immediate outcome? Women were allowed entry into the temple. There is a legal recognition of equal access, and the conceptual insights is equality applies in religious spaces, ensuring the fundamental rights and the constitutional morality prevails over discriminatory and social customs. So the court ruled that discriminatory customs cannot override the fundamental constitutional rights to equality and dignity for women. It stressed supremacy of constitutional morality over traditions. As I told, that as we speak in 2026, still there is a PIL filed and the case is going on in 2026. Let's see what happens in due course of time. Next case important, Navtej Singh Johar versus Union of India 2018. In a historic ruling, the Supreme Court decriminalized consensual same-sex relations by reading down Section 377 of IPC. So the applied even the consensual adults acts issues of discriminations against LGBTQ. The question was the violation of Article 14, 15 and 21, because the opposite sex relations are allowed. Why not same sex? Like male and female. So this is also a question of equality, dignity and personal liberty to choose the life partner. Can state criminalize private consensual acts? So Supreme Court has ruled that Section 377 is unconstitutional. Consensual same-sex acts are not a crime. It recognizes the dignity, identity and autonomy. So the outcome is decriminalization of homosexuality, legal protection of the LGBTQ individuals and end of fear of the prosecutions. Identity is the core dignity, privacy and liberty interconnected with each other. Morality of the Constitution is more than any custom or social prejudice, upholding the constitutional promise of liberty, identity for every individual. So here, the court affirmed that criminalizing private consensual acts violated fundamental rights to dignity, identity, and autonomy of LGBTQ individuals. Next, important, Supreme Court of India versus Subhash Chandra Agarwal 2019 case. This case brought the judiciary under the Right to Information Act. Very important because RTI sought info on judges' appointments, how the judges are appointed and whatnot, based on the Right to Information Act. The Subhash Chandra Agarwal wants to know. So the demand for asset disclosure of the judges, what is the how much asset one judge has, it needs to be disclosed. Question on transparency in the judiciary, and the concern was secrecy versus accountability. The core issue is the Chief Justice of India's office under RTI Act. How can you balance between transparency and independency? What is the privacy of the judges versus public right? So the Supreme Court has ruled that yes, CJI is the Chief Justice of India's office is public authority under RTI, Right to Information Act. So information can be disclosed subject to a balance, independence and privacy, and this is also case-to-case disclosure approach. So immediately the judiciary brought under RTI framework, no, there cannot be an absolute secrecy in appointments. It is also safeguarded the prevent of misuse. So finally we understand accountability and confidentiality, okay, that led to the balance. So balancing the public rights to know with the necessity of judicial independence. So here what we see is the it carefully balancing against necessity for preserving judicial independency and privacy. In the long term, it boosted the accountability. There are collegium reforms, and there is also open governance even in the judiciary itself. Next important case is Anuradha Vasin versus Union of India 2020. Responding to an indefinite internet shutdown, the court declared the access to internet is an integral part of the fundamental right to freedom of speech and expression under Article 19 and Article 21. So this was a case in Kashmir, the internet and liberty. After abrogation of Article 370, the communication and media were restricted. Impact on daily life and journalism, because without internet you cannot do that. So the question was, is internet linked with Article 19 and 21? Freedom of speech in digital age and limits on state imposed shutdowns. Supreme Court has held that internet is an integral part of the freedom of speech and expression. If there is restriction, it should be proportionate and it should be temporary. Indefinite suspension is not valid. So this is the landmark recognitions of internet access as a vehicle for the fundamental rights in the digital age. It ruled that any state imposed internet suspension must be temporary, necessary and subject to judicial review. This is the first recognitions end of arbitrariness and boosting the digital governance. If we go next, Vidya Devi versus State of Himachal Pradesh 2020. The state forcibly took widow's land. Widow disposed of land by the state. No compensation provided, no proper legal procedure followed. Abuse of authority. Core question was, in earlier times, right to property was a fundamental right, but later on, it was made only a constitutional right under Article 300A. Even if it is a constitutional right, it is violated. This is also linked to Article 21, dignity and life. Can state take property without due process? What is the Supreme Court's ruling? Supreme Court has held that the court reaffirmed that the property right Article 300 is a constitutional and human right, and the state cannot act arbitrarily, linking the right to property with a person's dignity. State actions must be lawful and fair, and there should be due process and compensation is mandatory. This is protecting the constitutional and human rights of vulnerable citizens against arbitrary state actions. Property, even though it is not fundamental, but it must be protected. So this has a long-term impact of protecting the vulnerable groups. There must be executive checks and upholding the rule of law. So this is coming under the theme of right to property and dignity. Next important case is S.G. Bombatkar versus Union of India 2022. The court put the colonial era sedition section 124A in abeyance. It has challenged the Section 124A IPC seditions, allegation of misuse against the dissent, colonial era law under scrutiny. So in sedition, what used to happen, the police used to pick up any person with a suspect that violence or disorder to the public order may happen, so they used to arrest. So the core constitutional is compatibility with the Article 19 and 21, free speech versus state security. Can such law continue in present form? Section 124A, Supreme Court has ordered, it is kept in abeyance. No new FIRs or arrest under the sedition. Ongoing cases put on hold, and it has awaited the legislation to reconsider and if to look into if there is any kind of amendments required. So immediate outcome is there is a relief to individuals facing sedition charges, temporary suspensions of laws, and pressure on the government to review this colonial law. A significant pause in the colonial era sedition law to protect democratic free speech. So here, this action was a major step towards protecting free speech and dissent in the modern democracy. Okay, so this has prevented sedition misuse, need for the legal reforms, and free speech jurisprudence. Next important issue is Karnataka hijab issue, 2022. This case involved the conflict between religious expression, that is wearing the hijab, and the institutional disciplines, that is school uniforms. Means students denied entry for wearing hijab into the school. Enforcement of the school uniforms rules, conflict between dress code and faith. So the question was violation of Article 14, right to equality, 19 and 25. 25 is right to freedom of religion. Can I not wear as per my own thing? So freedom versus institutional discipline. Court has observed that hijab is not an essential religious practice. Uniform rules valid and enforced. Later split the verdict in the Supreme Court, we observe. So the court delivered a split verdict, highlighting the ongoing complex legal battle on balancing individual religious identity with rules in secular educational spaces. So the immediate outcome was there are certain restrictions in certain institutions. Legal uncertainty after split verdict and matter remain debated. So navigating the complex intersections of the personal faith, school discipline, and the constitutional right in India, the long-term public debate is triggering limits of expression and rights versus discipline. So this is Karnataka hijab issue is related to religious expression and education. Next important is Anup Baranwal versus Union of India 2023. This is to safeguard the independence of Election Commission of India. The court created a temporary section panel for the election commissioners. So the issue was that there was no clear law on election commission's appointments. The executive had a dominant role, they used to decide. And the concern was in regards to Election Commission of India's independency. So the core question was how to ensure independence of ECI. Can executive alone control appointments? What is the need for institutional safeguard? The Supreme Court has ruled that there should be an interim mechanism unless and until there is a clear cut, I would say, unless and until there is a clear cut mechanism proposed by the Parliament. So in an appointment, there must be a panel. The panel is Prime Minister, Leader of Opposition, and CGI. As you know that in the later stage, you will find out there is a law in the Parliament, so it has removed the Chief Justice of India from the panel. So it applies until the Parliament makes law and to control. Okay, so here what happened, because the Election Commission of India is an important body to which controls the voting process of our country, so the independency must be protected. And if only executive body, only the government appoints the EC, then how come you ensure that there is no biasness? So ensuring the sanctity of the democratic process through the neutral and transparent appointment mechanism. Okay, so this is the a case related to Anup Baranwal versus Union of India 2023. Next case is very important, Supriya versus Union of India 2023. In the same-sex marriage, the Supreme Court ruled that while the right to choose partner is protected, it could not grant the legal right to marry under the existing law. Because Choosing partner and marrying are two different things. Petition seeks recognitions of queer marriages because demanding under there should be a special marriage act. So the issue is legal status of same-sex couple. See, living with partner and marriage act is different because when you enter into marriage legally, then it is not only staying together, but there are certain more things which are linked. For example, like property related to marriage. What would happen if the marriage did not continue? Who will be responsible for what? So those issues also comes into picture. Now, question comes that is right to marry a fundamental right? What is the scope of Article 14, 15, 21? Can courts recognize same-sex marriage? Supreme Court has held that no fundamental right to same-sex marriage. Court cannot rewrite the existing law. It is the part of the parliament to write down. Choice of partner is definitely protected, but marriage cannot be done unless and until parliament frames any law. So it shifted the responsibility for the legal recognitions of the same-sex marriage to the parliament, emphasizing judiciary is constrained and restrained in legislative matters. So let's see what happens in the future due course of actions. Next important case is MK Ranjit versus Union of India 2024. Protecting the endangered great Indian bustard from power projects, the court linked climate health directly to the fundamental right to life, Article 21, and Article 14, right to equality. Remember, right to clean environment made a fundamental right, now another one. So there was a threat to great Indian bustard because there is a power transmission project going on. The conflict is development versus environment. Question was, is climate change linked to Article 14 and 21? Can environment harm affecting the fundamental right? No. So the Supreme Court has ruled that climate change is a constitutional concern, definitely, but linked with right to life and equality. So the court has directed there should be sustainable design of the project and the environment safeguards should be strengthened. Now, this also has balanced renewable energy development with the urging protection of endangered species and fundamental rights. This landmark ruling elevated the climate justice to a constitutional concern, mandating sustainable development practices. The long-term impact is climate justice, linkage strengthening, and legal precedent. Very important, next case is ADR, Association for Democratic Reforms versus Union of India 2024 case. This case is regarding electoral bonds and transparency. So the context was the electoral bond schemes proposed by the government were challenged. Why? Because there were anonymous political donations since the names are not disclosed. So the concern was lack of transparency. The issue is if you disclose the name who are donating, then is it not violating Article 19 Clause 1 Subclause A? The voter's right to information. The voter has the right to know who is donating to whom, and is it legitimate or not? Is it legal or illegal? Can funding remain anonymous? So Supreme Court has held that the court struck down the scheme, ruling that anonymous donations violate the fundamental right to information of the voters, which is crucial for the transparent and fair elections. So it has directed disclosure of all the donor details. So upholding the right to information as a cornerstone of a functional and informed democracy. The long-term impact is electoral integrity, political accountability, and good governance. Next important case is Balram Singh versus Union of India 2024 case. This case is in regards to the word secular and socialist that is inserted in our preamble by 42nd Amendment Act 1976. So the challenge to 42nd Amendment changes claim that the distortion of the original constitution, debate of identity of the preamble. The core issue is, can preamble be amended? Do added words alter basic identity? If we add secular socialist, does it change anything? What is the compatibility with the original constitution? So finally the Supreme Court ruling is that these amendments are felt as a valid. Secular is a part of the constitution. Socialist is nothing but a social justice. So there is no violation of the basic structure. So the validity of the added words were confirmed, no change to the constitutional identity. So preamble reflects the core values. Secular means equal religious. The state does not have any official religion, but Indian state accepts all religions. Socialist is social justice. Okay, so upholding the dynamic yet fundamental character of the preamble as a soul of the constitution. Here, the it confirmed that these words do not change the core identity of the constitution, but only articulate values that were already foundation to the Indian state. In the long term, it has changed the constitutional philosophy, more clarity to the terms and the scope of the power. Next important case is in regards to the gene campaign versus Union of India 2024. The theme is genetically modified crops and environmental safeguards. So the GM mustard, genetically modified mustard, सरसों जिसको हम बोलते हैं DMH11, the case it was filed by the NGO Gene Campaign concerned that biosafety risk and lack of study and public consultation. The core issue was, does it violate Article 21 by forcing the mustard into genetically modified? What is the precautionary principle? Can approval bypass the safeguard? The Supreme Court has observed the challenging this approval of GM mustard. The court emphasized that food security and environment safeguard are linked to the right to life under Article 21. So, it states that there needs to be a scientific rigor, transparency, and public consultation in approval processes for genetically modified organisms or GMOs. So, the GM approval process was questioned. Higher scrutiny on biotech, emphasis on scientific validations. Here, health and environment are right to life. Science and public participation is necessary, integrating scientific rigor with environmental safeguards and public trust. In a long term, it has upheld biosafety standards, more questions to the environmental governance, and the constitutional links. Now, students, the last case we are going to talk is Bihan Kumar versus State of Haryana 2025 case. Here, this case is arbitrary arrest and inhuman custodial treatment. Arrest without informing reasons, no proper communication of the grounds, detained and chained to the hospital bed, allegation of the inhuman treatment. Question was, does it not violate the Article 22 of the Constitution? Does it not violate Article 21? Can illegal arrest be cured later? The Supreme Court has held that this arrest is unconstitutional. Chaining is violation of the dignity. Custodial treatment must be human. Illegal arrest cannot be validated later. So immediately there is a protection against the arbitrary arrest, emphasis on proper arrest procedure. Liberty includes dignity in the custody. Procedure must be fair and just. State power limited by human rights, ensuring that every citizen's fundamental right to dignity remains inviolable even in the state custody. So it reinforced the legal safeguard against arbitrary detention and procedural lapses by law enforcement. In a long term, the arrest safeguard is made, more police reforms needed, and the judicial vigilance is ensured. So the next case is in regards to the state of Tamil Nadu versus Governor of the Tamil Nadu 2025. Here what we see, there is a delay in the assent of the multiple state bills. The governor is not taking any actions. The bill on education, bill on reservations, which the Tamil Nadu government thinks are more crucial. So the conflict is state versus constitutional authority. What is the scope of Article 200? Can governor exercise pocket veto? Pocket veto means keeping the bill as it is without taking any actions, either yes or no. Should there be any timeline for the assent of the return of the bills? Supreme Court has held that there is no absolute veto or pocket veto. The governor must, as soon as possible, if withholding, it must return the bill. If repass, assentment is mandatory. Okay, so the immediate outcome is restricted arbitrary, strengthening legislative process. And this particular thing, you can say, our Honorable President Draupadi Murmu in the previous year, when 2025, I think end of the year, sought clarification from the Supreme Court under Article 143 advisory jurisdictions. Only, there are 14 points asked to the Supreme Court of India, and in those clarification, the Supreme Court has held that no, for the constitutional post like president and the governor, there cannot be any time limit that the court can insert. However, the court expects that there should be reasonable delay, and the delay cannot be indefinite. So these are the things which we are understanding. I hope that you like this video. I have tried to complete almost more than 50 cases, 55, 56 cases, all the details cases since 1950 till 2026. I'm sure that all of these cases which I have discussed are very much important, and do let me know in the comment box if you have any kind of questions. I'll be happy to clarify. If you want any kind of support, also do let me know. If you think that this video has helped you in a little bit way, then do share this video with your fellow aspirants. Thank you very much.